on the DSA, its future enforcement, and the protection of fundamental rights. The panel is organized by the DSA Observatory, which is a project that is running at the University of Amsterdam at the Institute for Information Law. What I will do is I will introduce myself, my co-moderator and chair, and the speakers for today. And then I will hand it over to Ilaria for some opening remarks about the substance and the focus of the panel. I'm Joris van Hoboken. I'm an associate professor at the Institute for Information Law and a professor of law at the LSTS group at the Vrije Universiteit Brussels. I'm joined here in the, also we organized this together. I'm joined by Ilaria Bouri. Ilaria is a research fellow at the DSA Observatory project at the Institute for Information Law at the University of Amsterdam. Then we have 4 speakers. The first speaker will be Jana Guz, legal policy advisor to Alexandra Giese, a Greens MEP in the European Parliament. Then hopefully who will join us still Paul Nemitz, principal advisor at DG Justice at the European Commission. Then Iriska Pirkova, Europe policy analyst and global freedom of expression lead at Access Now. And Elliot Bendinelli, senior technologist at Privacy International. So just for everybody that is in the session, everybody in the audience, this session is live streamed and recorded. Just as a quick point on the format of the session, we have asked all the speakers to give some relatively short opening remarks, 3-4 minutes. And after that, we will have a little bit more fluent discussion, and also, of course, will involve the audience. So you can type your questions, of course, into the chat, into the public chat. You can also indicate whether you want to come, like open your camera or ask the question yourself. So just saying that you have a question, and we will pick it up like that. Please do keep your cameras and microphones closed if you are not speaking. With that, I will give the floor to Ilaria for some quick opening remarks on the substance of the session. I did hear you before, so. At the moment, you're muted. No, I can't hear you. Try to refresh the page, it says, as a... Yeah. There's something with your microphone. Maybe you should try to refresh, come into the session again. But I'll just give it a minute because I want to give her a chance to say the things that she prepared. technology doesn't have to be perfect. Okay.
I'm back.
Yeah, we can hear you.
Hope
Great.
I have no idea what happened. I'm really sorry.
No, I mean, it's like
it worked at the beginning and it just stopped. So it took a moment.
We waited. Like, so please take it away.
So thanks so much, Joris, for opening the session, and everybody, including in the audience, for waiting a couple of minutes now. So I will just say a few words to introduce the substance of this session. So the main idea behind the panel session today and the very many questions that it wants to explore is the idea of creating a space for discussion for one of the most central aspects of the DSA process, which is the question of its future enforcement within the framework that is now taking shape in the discussions, and the question of whether these rules will be capable to deliver a high level of protection of fundamental rights and other democratic values. So this topic of DSA enforcement, despite being clearly one of the most prominent of the proposal and very central as to whether the DSA will or not achieve in the future its policy objectives, has not received a lot of attention over the past months, because other topics, also rightfully, have taken center stage, and this topic has been a bit overshadowed by other issues. So the reason why we think it's really important that we talk about enforcement today is because we know, particularly from experience with the enforcement of GDPR, that even the most ambitious set of rules do not translate automatically in high level of protection of fundamental rights without strong and consistent enforcement structures. And there is no doubt in this case that the many shortcomings, the failures in the enforcement of GDPR influenced heavily the DSA discussions, starting from the first Commission proposal to the following negotiations, particularly with this idea of a more centralized Commission enforcement against dominant platforms emerging really as the most promising solution to try to avoid the reoccurrence of some of the biggest failures that happened with the enforcement of GDPR. And the rationale behind this type of choice is very clear, is understandable, but we think it also raises a couple of complex and interesting questions that are very worth discussing today and in the coming months. Now, when it comes to enforcement against big platforms, one of the most interesting aspects concerns the supervision and enforcement of their obligations to identify and to mitigate systemic societal risks. And in particular, we saw over the past months, over the last few days, last week in particular, that systemic issues such as that connected to business model choices and surveillance-based advertising really emerged as some of the most heated topics in the entire DSA discussion. And these are all questions on which the Parliament report from last week takes a more ambitious stance compared to the Commission and the Council's text, and we'll talk about it. From this perspective, we think that one of the most interesting questions for today is certainly the question of whether the DSA provisions, and particularly the systemic risk management mechanism, where enforced properly, has the potential to deliver a high level of protection of fundamental rights and other democratic values, including with regard to some of the most striking distortions and violations of fundamental rights that are brought about by some business models dynamics. And more in general, another question we'd like to discuss with you today is the question of the potential challenges that we can already identify and anticipate today with respect to the implementation and the enforcement of the DSA. So I think I've spoken enough. I will speak further to not take away any more precious time from the conversation with our speakers. As Joris already said in the introduction, we have four great panelists today, and they all have outstanding experience both in the DSA and in the GDPR debates. So I'm now giving the floor to our first speaker today, Jana Goth. Jana is legal and policy advisor to MEP Alexandra Giese. Jana, you've been super busy over the past months, over the past year with the DSA negotiations, just back from last week's plenary in Strasbourg. So we are very curious to hear from you, from your vantage point on the DSA. What's your impression of the DSA enforcement chapter? The floor is yours.
Yes, thank you, Ilya. So I very much agree with one of the first things that you said, and that is that this entire enforcement chapter received way too little attention over the last months, both in public discourse as well, in my view, within the negotiations, because we initiated chronologically from front to end of the DSA, and I think the crowd the same, which naturally led to the enforcement chapter being one of the very last things being negotiated and discussed. And as you might know, there was a huge time pressure on the rapporteur to bring the file to a close. So in my humble view, I think we could have spent more time debating these things and negotiating on these issues than we did. In particular, as I completely agree as well, that we had to learn from our experience with GDPR. In my prior life, before I joined Ms. Giese as a policy advisor, I was working at a lawyer and advising big tech clients on GDPR and also vis-a-vis the DPAs and proceedings that they had with them. So I was able to draw from that experience and trying to bring it into, in particular, how we can improve enforcement under the DSA, which was one of the Greens' main priorities for the file. So what we did procedurally internally was really take a close look into what GDPR offers in this regard, and then draw our conclusions from there, and based from the experience there, try to translate that into a better enforcement chapter for the DSA. So the first thing that we thought needed fixing in comparison to GDPR was that we felt the need to introduce fixed deadlines for every step of the proceedings wherever possible. This is something that that we've seen in regards to Ireland. I personally, for example, lodged a complaint with my respective DPA in Germany. Together with none of your business back in 2018 actually already, and we haven't heard yet from the Irish DPA. There isn't even a first draft decision, and that is because there's no fixed deadline for them to actually come up with one of those draft decisions. So we can't even go to court yet. We can't appeal a decision that isn't in existence yet. So that was one thing that we as Parliament did amend in comparison to the Commission draft as well, was to just introduce deadlines everywhere where they are missing. There were already lots of them in there. The Commission obviously also did their work and also saw this problem already. We just touched up on some aspects of that in this regard. And then the second big topic that all institutions in fact tackled was that a bit more centralization in regards to enforcement does not do us any harm here. Of course, we have the country of origin principle, and of course, also under the DSA, in principle, the digital service coordinator of establishment shall be in power of the proceedings. That's clear. But in particular, in regards to the very large online platforms, we felt the need that there's the real need for more centralized enforcement. Because obviously, like these issues are naturally cross-border. They touch upon every member state citizen's interests. B, that's also some might have seen with Ireland in regards to GDPR, is that sometimes the member states' financial interests can be so intertwined with the financial interests of the tech companies doing their business there. If there are thousands and thousands of jobs depending on these companies having their main establishment there, that it might not be the wisest decision to lay basically all enforcement powers onto them. And C, of course, we will need a huge pool of technically and legally very expert people to be able to work on these enforcement questions. So we, for example, as Greens, we pushed for having an actual EU platform agency that should be in charge for the enforcement vis-a-vis the very large online platforms and in regards to their special obligations. That didn't find a majority, unfortunately. So we are in this regard more or less still with the Commission proposal, where the Commission will do some of these, will have some of these powers. I think we can talk more about this in detail later. There are, of course, benefits and cons to having the Commission do these tasks, but overall, in general, I would say it's a good development that we're aiming for a bit more centralization in regards to enforcement. And maybe as a last general remark, which I think we can also touch upon later more in detail, is that if you compare the three texts that we have now, so the Commission text, the Parliament text, and the Council text, is actually a combination of all three of them would bring us benefits right now. Classically, of course, the EP is always maybe a bit bashing the the Council's proposals, but here for the DSA, the Council, in my view, or in the Greens view, did good work on the enforcement chapter, and there are lots of good provisions in there, strengthening, for example, the Commission in enforcement that we in the EP text are lacking. On the counter side, and the EP text, we have some fixed deadlines introduced that were lacking in the Council draft, and also, as you mentioned, Ilaria, the provisions on the risk assessment and the audits, which of course would be great if they would find their way into the trilogue text. So it really remains to be seen what we end up with after trilogue, and I think there are very good aspects in all three texts that if we achieve to combine them, I think we're left with something pretty effective. Yes.
Great. Thank you very much. And it does sound like you did actually do quite a lot of work, but of course, maybe some of those enforcement discussions are rather technical and not so easy also to translate to a bigger audience. Paul, Paul Nemitz, Principal Advisor at the DigiJustice at the European Commission. The floor is yours for your opening remarks.
Yes, thank you very much. First of all, I would say, like on GDPR, we are really here in a finding process where the institutions engage. I really mean this, for example, in GDPR, if you remember, the Commission actually didn't dare to, in its original proposal, to propose anything where there was a strong center. It was a very weak center in the original proposal, and then the member states in the council developed these thoughts about, what does it mean if we have complete decentralization, given the fact that Google and others sit in Ireland, how is that going to work for our citizens? And this is how, let's say, the powers of the Data Protection Board were created to give, let's say, binding decisions on the way forward in some cases. And I see the same type of constructive engagement now on DSA. And I would agree that in both of the texts, Parliament and Council, there are really steps forward. And I think the Commission is very much looking forward to seeing sort of, this constructive attitude continue. In the end, I would say all institutions are in it here to make things work. And that is a big challenge in this new world. And let's say, we have to push as far as we can. But I would also say, without thinking that there is this or that perfect solution. I think in particular comparisons to GDPR, they are helpful to some extent. But I would caution against, let's say, and the tonality is sometimes a little bit like that, a discourse which is, GDPR doesn't function and now we have to draw the consequences. The opposite is true. If you look at the fines, we just have a year behind us where the fines have very substantially increased and they will further increase. We have now an upward competition. The US is still leading with $1 billion fine, 2 billions of Facebook fine from the FTC. But complex enforcement systems, first of all, are never perfect from a scientific point of view or from this or that political point of view, never. And they need some time to fall into the kinetics. And I think the kinetics in the GDPR system are good in the sense that there is a real threat that decentral authorities can act, and they are starting to learn this, if the lead authority is not acting. So I would say there are also some other things which are not parallel, and that's important to keep in mind. So first of all, we don't have the issue or the problem of this multiplication of constitutional level independence of an authority. That is a blessing on the one hand, but it's also a problem because, if you have constitutional independence, it makes people think they are, the only ones who have an interest here. And this obstacle we don't have in the DSA. So we can think about an institutional setting which works, but which does not create this, this very special class of constitutionally protected independence, and this discourse, for example, which was very much in the GDPR discussions against the Commission. Huge mistake. I mean, the Commission is the most independent body of all, according to the treaty. If you look at the rules of the treaty, the Commission is very independent, which leads me to a second point, the good old discussion, do we need a body outside of the Commission to enforce or inside? I think there are, as Jana said, this is an old discussion on competition and on other subjects. I do believe it's a huge fallacy to think that every time we create a new institution, everything becomes better. The opposite is true, and we can see this, for example, in the split between the Commission and the External Action Service. And I would also say here, to create yet another institution, it will only multiply the number of actors, and that in itself is nothing good in a world where the platform economy uses multi-purpose technology, namely AI, it will be everywhere, and is multi-sided. So I would say we have to think the other way. We have to start thinking about moving away from this, civil servants / politicians hobby that, for my file, I also create my institution. Yeah, that is the old way for the old economy of thinking about enforcement. And, this has been done in all areas of EU law whenever there's a legal act on consumers, on equal opportunities, on data protection, on telecom, on this and that. We create an institution with it. And now we have, in the platform digital economy, we have so many actors. They all have the same clients. The platforms are clients of all these regulators, and it's a mess. So I must say I'm quite happy if we can move forward in this proposal and leave this thing with the Commission, because then the Commission does at least competition and this. And it's a unitary body, and that's a huge progress. That is not a weakness, that is a strength. Look at the FTC in America. They are now, I would say, lucky enough to have consumer protection, privacy, and competition in one house, because it also has one huge advantage. The other guys are learning from the hardcore competition guys, and that is an advantage. So I would plead for maintaining it this way. And a last remark on making...
We have to move to the next...
a last remark on making things work when an institution is in place, because that's not the only issue. We also have to think about mechanisms which ensure that the institution afterwards is under legal pressure to work. And in GDPR, the big progress in comparison to the directive was that we have created a right of the citizen to a decision. And by the way, I don't agree with Jana that, if you have been waiting for 3 years, you can actually bring a case. You don't need a fixed deadline written in a text to be able to bring a case for non-action. So let's not only have an institutional discussion, but let's think about kinetics, what triggers what, and how can we motivate the institution, which then is the enforcer, also to act afterwards. That we have to work on too.
Thank you. Thank you very much. And that is, of course, a dynamic we see also with the GDPR, that there is a lot of pressure also in particular from, NGOs and individuals on
Absolutely.
the functioning of the system. And that is a very interesting feature also maybe to make a comparison. Eliška, you're next, please.
Thank you very much. I hope that everyone can hear me well. And please, those who had some technical difficulties at the beginning, don't worry about it. I'm usually the one who has the biggest difficulties with big blue button. So I'm giving the warning in advance if there is any technical glitch. So I agree with many points that have already been raised, and Access Now, together with other civil societies, very much agree with the point that enforcement mechanism of DSA was sort of a sidetrack topic from the beginning. And we actually issued a position on how, in our view, the enforcement mechanism should look like even before the DSA was actually launched. And many other civil society players were thinking how to actually learn from the past GDPR mistakes, that the legislation that is also often called a legislative success, but unfortunately to a large extent, enforcement failure. And many other elements were already named by academia and other players in the field why that's the case, besides the lack of funding and adequate resources provided to data protection authorities at the national level. The issue is much more complex, with the problematic so-called one-stop shop mechanism and also the lack of harmonization between these national procedures. Access Now regularly published a report on enforcement of the GDPR, and this is the ongoing research that is being updated on a yearly basis. And we identified throughout these years 4 main reasons why we see GDPR enforcement mechanism lagging behind, and these precisely 4 bases are a good start for the future of the DSA to actually learn from. So these are definitely the inadequate communication exchange between these national authorities, authorities. Then, of course, the lack of strict deadlines to answer the request for investigation and enforcement that is already somehow mitigated by the DSA, and I definitely agree with Jana. Then a lot of progress has been done by the European Parliament in that sense. There is, of course, still differences and some level of contradictions between the national procedures. And finally, ongoing difficulty with determining companies' main establishment. So we have Irish problem, so the issue of corporate capture, we have the Luxembourgish problem, and some commentators also point out to those countries that are currently experiencing so-called democratic backsliding without pointing a finger into any concrete directions, where we often see that in the field of the content governance, when it comes to the appointment of future digital coordinators, often these actually falls on the existing media regulators within the member states of the European Union that, however, similarly to some DPAs, lack the enough resources or even experience with the platform governance issue and content governance issues. So all of these imposes a big question mark, and also a question what we can realistically expect from the DSA as these upcoming regulation that seeks to change the platform governance within the EU as we know it, and what kind of basis for this enforcement are truly realistic. DSA, just to quickly wrap up, something that doesn't really have to be elaborated further for anyone in this panel is that there are sort of a layered system of the enforcement. There is a system at the national member states level that to a large extent does follow the example set by the GDPR. So it creates also the coordinator of the establishment. But it also mitigates certain things that we identified with the GDPR that are actually creating all these obstacles within the enforcement. And what I would like to pay specific attention today is that enforcement layer over the very large online platforms, where precisely the enforcement mechanism of DSA relies on the more centralized role of the European Commission. We as civil societies are always here to make sure that the accountability systems and independence of public authorities is in place, and that there is enough meaningful transparency, not only imposed on the online platforms, but also on individual member states and the way how they actually exercise these enforcement mechanisms. And while I agree that to some extent centralization might be necessary, I disagree slightly with the point that European Commission is so much independent. First and foremost, European Commission is the executive branch of the European Union's power. And we still impose more and more question what part of the Commission or the unit, the independent monitoring unit, will be actually responsible for what parts of the enforcement, especially when they exercise monitoring over very large online platforms. We do see a need for such a more centralized independent body, and that's something that I also want to underline. And whether that will be in the form of European platform super agency or whether it will actually look a bit differently, that's also something we need to actually address and answer in the following months, years to come. Nevertheless, I think it's extremely important to distinguish what such a centralized enforcement can do and can oversight. And in our view, we definitely see the space for creation of a public independent auditor, someone who can actually really oversight how very large online platforms comply with their due diligence obligations, whether this is connected to the risk assessment or conducting independent audits, or even to administer the access framework that currently exists under the DSA framework, which is the only way how to actually establish a proper accountability mechanism. On all of these, we definitely need to create such a body that would actually hold these oversight function, but we are not exactly sure whether it's a good or realistic idea to bring all of those other enforcement functions under the one umbrella of one centralized institution, because it might as well actually create the problems that we already know, but in the center of Brussels. So this would be just first introductory remarks, and I'm happy to continue this further in the conversation.
Thank you. Thank you. That was great. So we'll quickly go to our final speaker for his opening remarks. Please, Elliot, the floor is yours.
Thank you, and thank you for inviting me. I have much less expertise on the DSA than my co-panelists, so I'm instead going to cover previous international experience with GDPR enforcement, in particular in the field of ad tech. So back in 2018, when GDPR came into force, we've led a month-long work submitting a number of data subject access requests to data brokers, ad tech companies, and credit rating agencies in order to investigate their data processing practices. And we found a number of issues with what all of these companies were doing, which ended up basically with us submitting 7 complaints in Europe to 3 data protection agencies in France, the UK, and Ireland. And among those complaints, only a few actually led to investigation. So the Irish DPC, for example, started an investigation on Comcast. France started one on Criteo. But among all of those, only one actually ended up in some sort of enforcement. And that was the ICO in the middle of last year that launched an enforcement notice against a number of credit rating agencies in the UK. But even then, this enforcement hasn't actually been followed up. Experian, one of the credit rating agencies that was being investigated, appealed this decision, and they were in a hearing last year. So we literally haven't seen any form of enforcement on this side. No, more recently, over the past 2 years, we've been doing technical research on publishers, so websites that are kind of the front end of tracking-based targeted advertising. So we've looked at websites dealing with mental health, more specifically with depressions, and more recently, we've looked at websites that were publishing diet-related ads. And this research was basically focused on looking at the number of trackers that were on this website by default without any sort of human interaction. And we looked at the data that was being collected in quizzes and surveys. So for example, in the first research, we looked at depression tests offered by these websites and where the answers offered by users were going. And what we found is that a number of these websites actually share direct answers with third parties that are unnamed without any form of consent that is being requested beforehand. And again, we submitted a complaint, notably against Doctissimo, one of the biggest health-related websites in France. And despite having regulators telling us that investigations have started, we haven't seen any kind of enforcement. Now, the good side of this story is that because this research got a little bit of media attention, companies actually change their practices, but that's not enforcement in the sense we're talking about today. So for us, it's pretty problematic thinking about people their information. Sorry?
You started breaking up, just the last sentences.
Okay. Is it okay now?
Yeah, I think you're back.
All right, so to conclude, basically, for us, we see 3 main reasons, adding to echo what Eliska said, but like the reasons for this is that the agencies have limited resources. They keep telling us that. They keep telling us that they're investigating a number of issues at the same time, and it's hard for them to focus on something. We've also observed a lot of lack of coordination between data protection agencies, and it's really a shame when we're looking at actors like data brokers or ad tech companies who have like a global presence and whose case would need to be assessed by multiple regulators at the same time. And finally, we've assessed that the complexity of the ones is probably hard for regulators to, again, coordinate and basically take action against these global companies. So yeah, that's it for me, I think.
Thank you very much. Just a quick note: your camera is also frozen. I don't. It's fine. Your picture is fine that we're seeing, but maybe you want to try to get it to work again. So that was really quite a lot put on the table. So maybe I want to kick off with one question about how you're all imagining this new kind of digital service coordinator entities and also the new kind of European level enforcement agencies. Which type of people should we see within those agencies? Like it's not data protection enforcement. If data protection enforcement had a long history, with of rules, and I mean those agencies existed for a long time, but those enforcement structures for the DSA, it is somewhat of a new beast with different types of expertise also being needed. So what is your imagination in terms of those institutions? What kind of expertise, what kind of what should we expect, and what should we hope for, and what should we wish for, and what should we maybe be worried about when thinking about those agencies? That maybe like as a question to bring it to life a little bit too, because in the end there's going to be people in those agencies having to do certain work and creating a favorable enforcement environment for the whole ecosystem in Europe. Who would like to pick up on that?
Well, I can give you my experience from GDPR here. It is actually a huge problem that many of the data protection authorities are run by people who have absolutely no enforcement background, and the fact that these authorities are old doesn't change anything. There was a gentlewoman and gentleman's culture before GDPR. We have a cup of coffee, we agree, and basically no judgments which were of contentious nature whatsoever, which tells you everything about, let's keep life nice. So I have always said we have to change this culture for DPAs. We need, former prosecutors, deputy head of the competition authority. We need people who are ready for conflict and ready to go for hard hand, but also who know how to document evidence and how to do investigations and enforcement work in such a way that it stands in a court. And I think we need this type of people in the DSA enforcement bodies and coordinators bodies too. And I think there will be some more discussions about this, because, the vexed thing is that DSA, there's also an element of industrial policy always in the background, and, let's talk and be nice. But I would say, look, guys, we have learned ethics doesn't do it. And talking, and being nice with each other, no. We need, if we make laws, we need hard enforcement readiness, not unreasonable hardness, but readiness. And so that means we need people who are able and willing to stand the conflict, and who are able and who know and who have the professionalism to investigate in such a way that they are able to take a tough enforcement decision and then also win in court. And that is a different type of person than those who love to give the other's next speech at the school and the university and inform and go to the next conference of all the DSA enforcers and talky. So I would say we need people of action.
You want an enforcer with some teeth at least. Jana, please.
Absolutely.
Jana, you wanted to come in as well on this.
Yeah, if I can add to that, Joris, I think you already answered your own question partly. And the name of the new enforcement entities are very fitting. They're called coordinators, and I think that is one of the biggest challenges that we might face with the DSA enforcement in general. Is that, as you said, there are so many different backgrounds of expertise that we will need, and I completely agree with Paul that, of course, at the head of these institutions, we need people with teeth and with appetite for proper enforcement, but all the entire hierarchy below, of course, we need the technical expertise. We need people that have backgrounds in computer sciences. We need people that have backgrounds in media regulations, and so on and so forth. And the DSA already foresees the possibility or the likelihood of there being more than one competent authority per member state, and says that they will just need to organize themselves and just have one DSC that will also represent them at the board, for example. But that means that, and in comparison to GDPR, where we have a pretty clear-cut legal field that people can work in and have been working in for for years. Under the DSA, we will have many fields of legal expertise, for example, that are being concerned here. So we will not only have the issue of having to coordinate between member states, for example, and joint investigations, or coordinate at the board level. We will also have this need for close cooperation within one member state between many different already existing authorities. Some member states might create a new authority to be the DSC, some might build up on existing authorities, but in any case, there will be many different authorities concerned on the member state level. So we really need a close cooperation there, and we've already seen from past experience that, of course, this is always cumbersome. It's always a bit slow. There's always this issue of basically translation between different authorities, because they just have different working styles, they have different approaches to things. I think this is something we will need to look out for.
Eliska, did you want to come in as well?
Yes, I just would like to add to those great points that have already been raised by two previous speakers, that perhaps indeed the number of specializations and experts that will actually have to work on the enforcement of the DSA is quite large. And that's another reason why, in my view at least, there is definitely considering or worth of considering to see on one hand enforcement over compliance with the obligations within the DSA that could be indeed left with some independent enforcement unit at the commission level, and at the same time having actually that individual body, so-called, we could call it transparency facilitator, which is the term that comes from the Algorithm Watch, for instance, the organization that also proposes similar solution in that regard, that would be then responsible for certain elements, how to actually administer that buzzword of meaningful transparency that we all talk about and the DSA seeks to establish. And there we can actually see and foresee the role for the sort of agency that could administer that. Because if we speak about independent auditing of platforms that is envisioned within the DSA, that in itself is technically very complicated thing to actually enforce, where if we want to actually use those independent audits to the large possible extent, we need several expert bodies to be able to actually conduct those, and at the same time a body that will be able to oversight how those exercises are being performed, so we are not ending up with some checklist or completely privatized environment of audits that we saw also in the case of GDPR. So precisely due to that large scope of different regulators and different necessary expertise in the place of DSA, this would be actually one way how to think about it in the future. So I think both actually have their deserved place when we discuss enforcement mechanism. It's just that we should not try to create a body that wants to do too much at once.
Ilaria, do you want to put the next question, perhaps?
Maybe since we don't have a lot of minutes left, it would be good to open it up to the audience. And maybe there's someone who wants to come forward with a question.
There is an interesting question on the Digital Single Market Directive on copyright, how that relates to this discussion. Maybe someone would like to answer that. Not an easy question. I think there was just a report from the European Copyright Society on the relationship between that directive and the DSA proposal. How important
I could say some words to the. Sorry.
Please go ahead.
Of course, the general interlink between these two regimes is a bit complicated, in fact, and there is a good report on this out there. But in particular, in terms of enforcement, I don't think we have huge issues here, because DSM is enforced is enforced on the member state level. It's a directive, right? So it's transposed into member state law, and it's more about the content of things. So as soon as we can clear up the interlink between those two regimes in general, then I think we should also be fine on the enforcement side of things. And then again, Of course, at a member state level, no matter who will be appointed to be the DSC, of course, the media regulators will play their role in the enforcement of the DSA as well, at least in just giving input and expertise to the DSC, if it's not them in the first place being the supervisory authority.
There is a question about the importance of fines. Are there views on the importance of fines in all of this? Paul, you're muted.
Yeah. You know, I'll tell you an anecdote. So while we were negotiating GDPR, some of the big tech companies came to me and said, oh, you know, we're never going to talk to the regulator if they can fine us. You know, that's not good for nice conversation. And my answer was, yeah, sure. That's why you constantly talk to DG Competition, which can fine you 10% of world turnover. So actually, you know, I believe in the possibility of high fines. It is conducive to the dialogue with the authority, and it's also helpful in bringing about real change. You know, in enforcement, nothing is perfect, but, you know, better have the hard hand possibilities because, you know, nothing just changes because we have a nice coordination. So I just also want to say one thing about this constant excitement in civil society about independence. I think it's a huge misunderstanding. Independence from what? From political oversight? I mean, hello, normally all enforcement of law by public bodies is part of political responsibility. So why are we giving the benefit to the digital economy and constantly say, oh, we need independent enforcement? Hello, that means we are setting up weak bodies which are out there in the landscape instead of making them part of the pre-existing strong state. I think that, you know, you guys, you have to rethink this a little bit. There is nothing good in this, you know, oh, and another body which is independent and another body independent. They are just weak. The normal enforcement, you know, think of tax enforcement. Think of enforcement of, you know, phytosanitary. I mean, any type of public law is normally enforced by the state, full stop. And there's a political responsibility of a minister that the enforcement takes place, and they got to be tough. Yeah. And in the moment you create an independent body, you get this problem of these bodies out there, and, you know, where is the line to democracy? So I would say, you know, there is a misunderstanding. This word independence, it sounds great, but it has a very limited positive function. It can be very detrimental to create all these weak bodies outside the direct political accountability to Parliament.
Yeah, I think, I mean, it's obviously, I mean, there's some good reactions to that in the chat. Maybe I'll let that kind of happen. Maybe just another point to bring up, also considering what you said in the beginning, Elliot, about you know, your engagement with Privacy International within the GDPR kind of enforcement ecosystem. The DSA has a lot of this, you know, kind of, it has this whole imagination of other actors playing an important role in the enforcement of the DSA. There's a particular role also for academics. They get, no researchers, they get potential access to certain data that they can start to use to do research about dynamics on dominant platforms. I think there's also a role imagined for civil society. So it's like, it's really a bigger ecosystem of actors that has to play some role in this. So, Elliot, could you speak to that? And what do you think about the current situation, and what is your experience with that from working in the GDPR context?
So, I'd like to reiterate, but my expertise about the DSA is fairly limited. So I've done a bit of reading before this panel, but it's definitely not on par with my co-speaker here. But my impression is that what the DSA is And in terms of enforcement, when it comes to the topic we researched at least, so I'm talking ad tech and surveillance-based online advertising, I feel like it's still missing out on a big statement, should I say. Like some of the things we've observed is that there is a lack of agreement between the DPAs on what is lawful or not lawful and what the DPR actually means and how it should be enforced. And I don't think the DSA is necessarily addressing this in a better way. And so, sure, data sharing with academics being sort of protected or set up by such a text might be a good thing, but we're still not addressing the core issue of online data collection and profiling and all of the data processing used and follow from this. And like from my limited understanding, I think this is still missing out, and it's not going to be helpful for GDPR enforcement in the future.
Thank you. We are almost out of time already. We have 5 minutes left. So maybe, I mean, we're of course, we're in the middle of this still. You know, like we just had the European Parliament plenary vote with some exciting improvements, I think, that we can be excited about. There's going to be trialogue. What is still possible, and what are you aiming for in that particular context? Maybe that is a nice question to close with. What is still possible in the coming months in terms of improvements, also in particular on these issues that we've been speaking about?
If I may start. Of course, if we are now discussing whether or not we like the Commission in this role, it's of scientific value, but we won't be able to change that anymore with trialogues. We have the EP and the Council mandate and the Commission text, and our only negotiating power will be between these three texts, right? So we will end up with the Commission being in this role. And I think what's worth investing now is how we can make that a sound role, how we can maybe still introduce some safeguards that Eliška was talking about, how we can further ensure independence and so on. So there's, between the text, of course, there's very limited room for introducing new ideas, but I'm hopeful that we can work out in some of the recitals, maybe some clarifications into what we actually expect from the Commission. And one thing that I regret that it did not find its way into the final text was that I would have really valued, or we would have really valued, a review clause also in regards to the enforcement chapter, because as everyone I think today rightly pointed out, it is a huge challenge. We shouldn't blindly follow our learnings from GDPR, but we should also acknowledge them. The challenge is to kind of find our way through here, anticipate what's about to come. So being able, after a couple of years, to sit down again and review whether the enforcement chapter the enforcement system that we came up with makes sense, whether it makes sense, and how far it makes sense to give these powers to the Commission, if it's working out fine, to see whether maybe this unit that will end up working on these things in the Commission could be outsourced at a certain point in time in the future. All of these are questions that will be way harder to answer if we're not able to properly review the text without opening up the entire file again. But yeah.
Thank you. That's insightful and seems those seem to be very reasonable objective. We have like 2 minutes left, but I want to give each of the speakers just a chance to say some final things. So maybe 1-2 sentences each. Eliška, please.
So very practically speaking, what's next for us is to sit down, what we are actually already doing, very closely compare European Parliament position with the Council position, realistically assess where we need to invest our powers, continue promoting those safeguards I mentioned today in the context of the enforcement, but also other priorities that we have, and hoping that we will actually create a check and balance system, a mechanism that where I will repeat, independence plays significant role, because without independence there will be no proper accountability, in my view. And someone even mentioned Article 8.3 of the Charter of the EU. So in the chat. So all of it will be in hands of. Looking forward to cooperate with the Commission as well as with the European Parliament on getting the best possible law on regulating platforms and especially protecting users and their empowerment at the end of this process.
Thank you. One sentence each. Elliot, Paul.
I'll let Paul go. I don't think I have anything valuable to add to this discussion, but thank you for my panelists.
If you want a strong enforcer, I think it's good to leave enforcement power in the Commission, look at competition, look at infringements against member states. Anything else are Schnapsideen. Also, the Commission is the most independent body. It's a strong body which is not easily captured. It's not a small, regulator who. So, think about this.
A consistent message, Paul. I am not entirely sure that you convinced everybody in the audience.
Obviously not, but
this was a fantastic discussion. Thank you so much. With the DSA Observatory, we will continue working on this topic. I want to thank you very much. Thanks very much, in particular to the speakers, but also to the audience for joining the panel and engaging. And let's close it for this. Thank you very much.